Hello everyone. Today we're going to demystify a term you might hear in legal settings, the preliminary conference. It sounds formal, but understanding it is quite straightforward and important for anyone involved in a lawsuit or certain administrative processes. So, what exactly is a preliminary conference? Simply put, it's an initial meeting held early in a legal case, usually before a trial begins. It's not a trial itself, but a crucial step to get things organized. The main goal is to manage the case efficiently. Think of it as a planning session. The judge and the parties involved, or their lawyers, come together. They want to figure out the best way to move the case forward. This helps avoid unnecessary delays and costs later on. Typically, the judge presiding over the case attends, along with the attorneys representing the plaintiff, the person suing, and the defendant, the person being sued. Sometimes, the parties themselves might be present, especially if they are representing themselves. During this conference, several key things happen. First, they discuss the scope of the case. What are the main issues? What facts are agreed upon? Second, they set a timeline for the case. This includes dates for discovery. Discovery is when both sides gather information and evidence. They might set deadlines for exchanging documents, taking depositions, out-of-court sworn testimonies, and filing motions. Third, they explore settlement possibilities. The judge might encourage the parties to talk about resolving the case without a full trial. This can save everyone a lot of time and money. Fourth, they might identify any special needs for the case. This could be the need for expert witnesses or specific types of evidence. Fifth, they could even schedule future court dates, such as a pre-trial conference or the actual trial date. The benefits of a preliminary conference are significant. It streamlines the legal process, making it more predictable. It helps clarify expectations for all parties. It can also lead to earlier resolutions. This reduces the emotional and financial burden of prolonged litigation. It's all about making the journey through the legal system as smooth as possible. It's important to remember that not all cases require a preliminary conference. The need for one often depends on the jurisdiction, the type of case, and the complexity of the issues involved. However, when it does happen, it's a foundational step. Thank you so much for tuning in and learning about the preliminary conference. We hope this explanation was clear and helpful. If you found this video useful, please give it a thumbs up, share it with anyone who might benefit, and consider subscribing to support our efforts in bringing you more helpful content like this. Your support truly helps us continue creating educational videos. See you next time.